Okay. What is your name and position?
My name is James Spalding, and I'm a labor mediator with the Michigan Employment Relations Commission Bureau of Employment Relations.
Jim, what is your background and what is mediation?
My background is varied. I started as an air traffic controller and was a local union president prior to the air traffic control strike in 1981. Following that, I went to work for the International Union of Operating Engineers as a union representative representing primarily public sector employees in industries such as public schools, county government, and some court employees, in addition to a medical care facility. After about 4 years there, I was actually recruited to come to work for the Michigan Association of School Boards, where I became a management consultant and represented boards of education in contract negotiations with public school employees. During that time, I had taken the civil service exam and had scored high enough that I was on the list for hiring as a labor mediator with the state of Michigan, and was contacted and asked if I was interested in coming to work for the state, and have been a labor mediator now for 16 years.
What do you do as a mediator?
As a mediator, I try to bring the parties together that are in dispute over contract negotiations or a grievance, and try to find a way to work with the parties to understand what their interests and concerns are and seek resolution that they may not have thought of, or they may be too close or too emotionally involved in the dispute to be able to recognize potential solutions that are available to them.
What do you like about your job?
What I like best about my job is being able to work with people and to be able to help people find resolution to issues that they think just are unresolvable at that point in time. It's very rewarding at the end of the day to have them say, "We're really glad that you came, but we hope we never have to see you again."
When is mediation most effective?
Mediation is most effective when parties show up with an open mind and a willingness to try to resolve their disputes. Quite often we find that people show up with hardened positions and they really don't want to talk with one another or try to find solutions. They just want to win. And sometimes we find that we have to break that barrier down first and get the parties to be open to the idea that settlement is possible and that we can find a way that both sides can walk away with a settlement that they think they can live with.
You've somewhat answered this, but when is mediation least effective?
Least effective mediation would be really when the parties just are hardened and absolutely dug in. There are some rare occasions where the parties have really adopted a philosophy that they aren't going to make any more movement at the time that the mediator gets there. And since it's almost a consensual process as far as getting people to change their position, because I can't force anybody to do anything, if people are unwilling to move, then it's really a waste of my time to even be there. However, I do try to continue to work with the parties, even if they say there is no room for movement. I find that if I continue to work with them and chip away at it a little bit, sometimes we find that settlement is still possible.
Do you ever speak to the press or the courts about mediation?
By statute, mediation is a confidential process, so I have never spoken to the courts. I have been subpoenaed in the past, but have never had to appear before a judge because of the confidential nature of the process, and by statute it is protected. With the newspapers, generally what I have done when I've been contacted by a reporter is respond to the reporter and let them know that the mediator is a confidential element in the bargaining process, and I cannot share any information with them whatsoever about the process that I'm involved in.
What is the difference between mediation for collective bargaining and grievance mediation?
Mediation for collective bargaining really involves a number of disputes simultaneously that are the formation of a collective bargaining agreement and what possibilities might exist to resolve the problems that people might be dealing with, whether it's application of seniority, layoff and recall, what kind of wage increase they're going to have, what are their health insurance benefits going to look like. So it's pretty much free-flowing, and we're only limited by our creativity in that regard to trying to find what's possible, what the parties feel they can live with to resolve their contract. In grievance mediation, we're dealing with an actual specific allegation that the contract has been violated, and what we're looking for there again is resolution of the issue. In grievance mediation, the value of that, rather than being involved in arbitration, is that arbitrators are limited to interpreting the written terms of the contract. They can't add to, take from, or alter the collective bargaining agreement. In mediation, we're not bound by the collective bargaining agreement, so we can seek solutions that may not be consistent with what the express language of the contract may be, but the parties can always agree to maybe reach some sort of a letter of understanding where they can modify the contract or define the terms of the contract through their settlement and actually resolve the issue that's in dispute rather than interpret the contract.
What do you do in grievance mediation?
What I do in grievance mediation is tend to listen to both sides as far as what their concerns are, and then I will separate the parties and start to go back and forth and share my ideas about what I think the issue really might be. Quite often I find that the parties are so focused on whether or not the actual language of the contract was violated that they lose sight of the underlying issue that caused the grievance in the first place. If we focus on why somebody felt something wasn't right, rather than what the contract says, sometimes we find that we can walk away with the parties actually having a better relationship with one another and solving problems that both sides say, this will work into the future and we're better off for it.
Is mediation free in the state of Michigan?
Mediation is free within the state of Michigan. It's provided under the general fund of the state of Michigan as a general fund budget item.
Thank you very much, Jim.